All right, guys, we have something that is really cool and it's going on and it is amazing. We have another complete victory fatality. This time at the circuit level. This is a case that is brought by the Firearms Policy Coalition, and it is from the Ninth Circuit Court of Appeals, and it's actually two different cases, or multiple different cases combined. But it was argued in front of a three-judge panel, including Mary Schrodinger, Susan Gaber, and Jennifer Sung. And it is this is not only Firearms Policy Coalition, but it's also Second Amendment Foundation, Firearms Policy Coalition, Gun Owners of America, Orange County Gun Owners PAC, California Gun Rights Foundation. It's a bunch of different places. So California Pistol Rifle Association, Gun Owners of California.
Nice.
A bunch. And basically what this is a case that was dealing with restrictions on concealed carry. And basically, they ruled that in Hawaii, they cannot ban the concealed carrying of firearms in banks, parking lots adjacent to banks, parking lots shared by government buildings and non-governmental buildings. In California, they can't ban guns in hospitals, medical facilities, public transportations, gatherings that require a permit, churches, places of worship, banking, financial institutions, and parking areas connected to those places.
Man, that feels good. Just to hear you say it feels good.
Yeah. So this is a super case because there's so many different.
Now, so this is a three-judge panel on the Ninth Circuit Court. Is it a roll of the dice as to what judges you get? And it could have gone the other way, depending on the judges.
It could have gone the other way. It's not a total victory, but because like there's some other places where they held up the injunction for a lot of different places, but there are some places where they removed the injunction from.
So could they ask for an en banc?
Yeah, I'm not sure which side's going to ask for an en banc. Somebody will. But let's go ahead and read through this.
So I misunderstood then. So there are some downsides to this.
There's some downsides.
Yeah.
So it's a win. It's maybe a temporary win because they'll definitely go en banc.
It's a win in some places and other places not a win. So that is something. Alan Beck, as you know, was one of the counsels on here. You know Alan Beck, right?
Yep. Not like, I know him, but yes. No.
Yeah, Alan's a good guy. And there was a bunch. So yeah, so if you look through this is all the different injunction, all the people that issued, uh, amicus briefs and everything. There's tons.
Okay. Was that all of the attorney generals offering amicus briefs?
Yeah. So let's just go ahead and read through some of it. It's like 13 pages of amicus briefs. All right. So who wants to go?
Dark, you go.
Okay, I was about to say, Rich, you go. In its modern decisions concerning the Second Amendment, the Supreme Court has emphasized that its rulings do not call into question long-standing laws prohibiting the carry of firearms at sensitive places, such as schools and government buildings.
All right, we can
So
skip all that.
Okay. Parks in modern form, for example, first arose in the middle of the 19th century. Governments throughout the nation immediately imposed prohibitions on firearms in parks. The constitutionality of those bans was unquestioned, and those regulations are akin to laws recognized by Bruin as sufficiently representative to qualify a location as a quote sensitive place.
DS 88, it is a mixed bag.
States permissibly may prohibit firearms in most parks. By contrast, banks have existed throughout our nation's history, but the historical record does not demonstrate a comparable national tradition of banning firearms at banks. Applying Bruin's guidance, we conclude that the Second Amendment likely prohibits a state from banning firearms in banks. But that conclusion is less restrictive than it may appear at first glance. As the owner or operator of private property, a bank may prohibit firearms as a matter of the ordinary property law right to exclude.
Okay, basically what they're saying is that it's up
On-
to the banks. It's not up to the states.
Yeah, yeah. So on an individual basis, anyone for that matter, not just a bank,
All
but in
right,
this
then
case,
it's gonna go into the Hawaii law where forbid, and it's gonna talk allegedly, or where it's gonna talk about a different thing. So, like, basically, any bar, restaurant serving alcohol, any beach, playground, parks adjacent to parking areas, premises of any bank, financial institution, any person who violates section will be guilty of a misdemeanor. So, it basically just goes through that, and they also try to do the whole New York thing where you had to post signs.
hmm,
In
Post
California,
signs saying that you are allowed to carry a gun.
yeah, in California, it's a banking, real estate prop, like any like preschool, childcare, uh, building, parking areas, proportion of the building that controlled by an officer or executive of the legislative branch of the state government buildings, court buildings, another government building, parking under the control of a juvenile detention center or correction institution, buildings, property, and parking under the control of private hospitals, buses, private transportation, uh, anywhere where intoxicating liquor is sold for consumption on premises, that's bars and everywhere else. Special events that require a permit, parks, athletic areas, anything that recreation park, like like whatever, or any property designated for hunting, colleges, anywhere where there's gambling, stadiums, airport parking lots, which I don't understand, public libraries, amusement parks, zoos, museums, anywhere that they store nuclear power, any houses of worship, banks, police stations, polling stations,
Partridge and a pear tree.
and the whole entire you must post signs thing again. So yeah, so it's a lot. So let's just go through here. Rich, start.
Boom. In Carrello, plaintiffs Morocco Antonio Carrello, whatever. Garrison Ham, blah, plaintiffs. Wow, it's all plaintiffs. Plaintiffs, Orange County. You really want me to read this? Plaintiffs.
You have to read all the plaintiffs. It's a bunch of CRPA, GOC, GOA, SAF, and the other case
All right.
is
So I think plaintiffs moved.
yeah. So you can just go here. Let's just go to the discussion.
To warrant the extraordinary relief of a preliminary injunctive, plaintiffs must show a likelihood of success on the merits, irreparable harm in the absence of preliminary relief, a favorable balance of the equities, and favorable public interest in an injunction.
Basically, what
Because
they're saying here is that you have to prove likelihood to succeed on the merits. The public balance of have to land with whoever the injunction is for. So the big thing is likely to succeed on the merits. So I'm just
with
trying to get
respect
to the meat of this stuff.
the meat,
All right.
not the bone.
Okay. And then just going to talk about how I said in Rahimi, it's a historical analog, not a twin. So let's go start from right here, Rich.
Rather than taking the more nuanced approach, the Supreme Court applied the distinctly similar test in both Heller, which concerned a ban on handguns, and Bruin, which concerned conditions for obtaining a concealed carry permit. In applying that test in Bruin, the court was strict in its search for a distinctly similar regulation that could justify New York's proper cause concealed carry permitting requirement. In exhaustive historical analysis, the court held that no early law was analogous to the proper cause requirement, and the court also noted that several state courts had ruled in ways that were contrary to a proper cause requirement. Although the court ruled that the defendants' proffered colonial laws were not on point, the court began its analysis with dictum. For starters, we doubt that 3 colonial regulations could suffice to show a tradition of public carry regulation.
This
The
is just
court
going to
acknowledged.
This is just going to go over Bruin. And it's going to tell you about the Bruin analysis, text, tradition, and history. First step is for the plaintiffs to prove that their action is protected under the plain text of the Second Amendment, which means that they are a part of the people, which is the political part. If you can vote, you're part of the people, part of the political class, they call it. And then it moves to the second part of the test, which is a historical analysis, where the defendants, the state, have to provide historical analogs from the founding era, the ratification date of the Second Amendment, although some people try to argue that it's the ratification date of the 14th Amendment, which was during the Jim Crow laws. But most legal scholars believe it's the ratification date of the Second Amendment, which is in 1791, as the founding era. As the laws get farther away from there, the less weight that they have. Now, in Rahimi, they said there doesn't have to be a historical twin, but the laws have to be similar. That's what they're saying here, but it's all they spell it out. They go way deep instead of just saying that. So they're talking about basically they're explaining what they're doing to do it, and they're going to do a Bruin analysis on it. And the state here tries to argue that if a sensitive area has some similarities with one of the places that they banned, then hey, they're allowed to ban it. So it doesn't have to be listed as once a sensitive. It doesn't have to be a sensitive area. It just has to be similar. Have some.
So if they say park and you're at an arboretum.
Yeah. So let's go. So they're going to go through all of it. Let's go parks in similar areas.
Wow, that's kind of crazy. Both state laws prohibit the carry of firearms in a park. Penal code, boom. Plaintiffs in both cases brought facial challenges to the relevant provision in distinct courts. In the district courts in both cases concluded that plaintiffs are likely to succeed on their facial claims. We disagree. Parks in modern form are outdoor gathering places where people engage in social, political, and recreational activities. on the present record, plaintiffs are likely to succeed in their assertion that public green spaces that existed in 1791 were
Or
akin to a modern park.
unlikely.
Hmm.
So
Oh,
basically,
unlikely.
they're upholding the park ban here.
Wow.
All right.
Dang.
Now let's. So it goes into that. You're going to uphold the park ban, but let's go to playgrounds and youth centers.
In the California cases, the district court held that plaintiffs are likely to succeed in their challenge to the California Penal Code law, which prohibits carry in a playground or public or private youth center as defined, and street or sidewalk immediately adjacent to a playground or youth center. Except for the district court in this case, every court has rejected the argument that firearms must be allowed on playgrounds.
So basically, they're saying playgrounds didn't exist in the founding era. They can ban them.
Wow.
All right, let's go to number 3.
Dang.
In the Hawaii case, the district court held that plaintiffs are likely to succeed in challenging Hawaii Revisited Statute Section law, which prohibits the carrying of firearms into any bar or restaurant serving alcohol or intoxicating liquor. In the California cases, the district court ruled that the plaintiffs are likely to succeed in challenging the California Penal Code, which prohibits carry in establishment where intoxicating liquor is sold for consumption on the premises. We disagree.
So they're basically saying that they believe in the founding era that they would allow that. So that was allowed to stand.
What,
So let's go
what
to
a mixed bag of nuts.
amusement.
Wow.
It's a mixed bag, like I said. So let's go.
In the California cases, the district court held that the plaintiffs are likely to succeed in challenging California Penal Code with respect to the places of amusement, casinos, stadiums, amusement parks, zoos, museums, and libraries. The parties and the district court did not distinguish among the first 3 types of places, each of which is a modern social gathering place for amusement. We follow the parties' lead in analyzing those places as a group. We also include zoos, museums, and libraries, which are places visited both for amusement and educational purposes. As noted below, historical laws banning firearms frequently classify those categories of places together. We hold that the plaintiffs are unlikely to prevail on these claims.
All right. So they basically knocked that down. But let's go and see what else they did.
Rich, you want me to take over?
Sure.
So they're gonna address them separately. Okay, go ahead.
At parking areas?
Yeah.
The topic of parking areas, so it says parking areas connected to sensitive places. The topic of parking areas connected to sensitive places arises in both the California and Hawaii cases, but the issues on appeal are distinct, so we address them separately. California cases. California Penal Code section blah 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 prohibits concealed carry in many parking areas associated with sensitive places listed in that section. Prohibiting carry at any building, real property, or parking area under the control of a zoo or museum. Prohibiting carry at any parking area under control of a law enforcement agency. The district court held that plaintiffs are likely to succeed in challenging the entire California Penal Code section blah as it pertains to all parking areas listed in that section. And for anyone curious, it's Penal Code section 26230. The preliminary injunction therefore allows concealed carry in the parking areas at most listed places, even those not challenged by plaintiffs. In other words, in addition to parking areas at most of the sensitive places discussed in this opinion, the injunction applies to parking areas at preschools, child care facilities, government buildings, courthouses, jails, prisons, juvenile detention centers, schools, airports, nuclear power plants, and police stations.
So basically, they're rejecting that and they're saying that, but they're going to break it down.
Yeah, it says we reject the district court's blah, blah, blah. Some parking areas, such as a parking garage located in the basement of a courthouse or jail, are likely so intertwined with the main structure as to be considered part of the sensitive area itself. Other parking areas, such as a student only parking area at a school or a fenced, gated parking lot at a jail or nuclear power plant, likely fall within a reasonable buffer zone such that firearms may be prohibited there. We agree with those courts that have held that, depending on the factual circumstances, firearms may be prohibited at some parking areas connected to sensitive places.
So they're basically saying it depends on the parking area.
Yeah.
So they're saying that's not the case. All right.
Wow.
So let's go.
Plaintiffs primarily argue that some parking areas are insufficiently connected to a sensitive place, such that the parking area is not reasonably covered by the ban on firearms at the sensitive place. For example, a parking area that is shared with ordinary businesses or a parking area that is geographically remote from the sensitive place might fall outside the nation's tradition of regulating sensitive places and that corresponding buffer zones. And the corresponding buffer zones. Plaintiffs contend that because it would be unconstitutional to ban concealed carry in some parking areas, California's ban must fail on its face. That mode of analysis is contrary to the proper analysis of a facial challenge. And they reference Rahimi.
And they're going to talk about like they're going to go back and talk about that. So they're going to say the plaintiff's unlikely to succeed.
Gotcha. Hawaii case. By contrast to the injunction entered in the California cases, the district court in Hawaii case enjoined defendants solely from enforcing the law in parking areas shared by governmental buildings and non-governmental buildings. Parking areas owned, leased, or used by the state or a county which share the parking area with non-governmental entities are not reserved for state or county employees, or do not exclusively serve the state or county building. Neither party appears to dispute that persons may carry firearms onto that subset of parking areas, but the parties disagree as to why. In defendant's view, the state law prohibits persons from bringing firearms only into areas used exclusively by the state. Plaintiffs want to bring their firearms only onto shared lots, not exclusive lots. Defendant thus urges us to conclude that plaintiffs lack standing to challenge the law with respect to shared lots. In plaintiffs' view, the law appears to prescribe their desired conduct, so they have standing to seek injunctive relief. And the injunction is proper because they prevail on the merits of the Second Amendment challenge with respect to the law's apparent prohibition on carrying firearms onto shared lots. On appeal, defendant is not challenged meaningfully the Second Amendment analysis as to shared parking lots. We hold that at least for the purpose of the preliminary injunction, defendant has fortified any argument as to the merits.
All right. So they're saying
Because,
they probably would.
yeah. Because standing is a jurisdictional requirement, though, we must address the issue. They cite case law. Plaintiffs do not allege an actual injury. They allege an imminent future injury, criminal prosecution for taking their firearms onto shared lots. For that reason, plaintiffs have standing only if they have alleged an intention to engage in a course of conduct arguably affected with a constitutional interest. 2, but the conduct is proscribed by a statute. And 3, there exists a credible threat of prosecution thereunder. They cite case law.
Let me just explain something. Rich, don't comment on this, but in the Florida case about open carrying and stuff like that, for a long time they would say, "Oh, there's no, threat of enforcement," and even though there was, but then some dumbass sheriff posted on social media that if you do, I'll prosecute you, which gave a credible threat of enforcement. And that's why that sheriff, the one that Rich is suing, which he's not going to talk about, but that's the reason why they have standing, because now that sheriff in that county made a credible threat.
Yep. Where are we at? As several courts have remarked in similar circumstances, the situation is peculiar in that the would-be sanctioned party must argue that the law does apply, while the would-be enforcing party, the Attorney General, could defeat standing by conceding that the law does not apply. Describing the reverse roles in similar terms, I guess that was the case law. We follow the approach taken in Peace Ranch
LLC
Oh,
versus
sorry.
California.
Yeah.
FEC versus.
And as we did there, conclude that plaintiffs have standing, holding that the plaintiffs had standing in similar circumstances, concluding that the plaintiffs had standing to challenge New York's sensitive places law, describing the Supreme Court's analysis and holding in Babbitt v. United Farm Workers National Union, and concluding that the inquiry in this context sets a low bar and requires a quite forgiving approach. Rich, you take over. I got to grab something real quick.
All right. So basically, they're saying that they have standing.
Are we at accordingly?
Yeah.
Accordingly, we agree with the district court that plaintiffs have standing because defendant has forfeited any argument on the merits challenging the injunction as to shared parking lots. We also agree with district court that
All right, we can skip all this. We can skip all that. Basically, what they're saying is that they were not trying to win on the merits of the case. They were trying to win on the standing issue. And since they have standing, the defendants never really argued merits. They only argued standing. So therefore, the default win.
Gotcha. In both the Hawaii case and California cases, district courts held that the plaintiffs are likely to succeed on their challenges to respective bans on carry of firearms on private property held open to the public unless the owner or operator consents. Although the state statutes are similar, they differ in one key respect. Hawaii's law allows a property owner to consent orally, in writing, or by posting appropriate signage on his site. California's law, by contrast, allows a property owner.
They have to post a sign.
Okay.
All right, keep on going.
As an initial matter, we hold that the plaintiffs have standing. Defendant in Hawaii case contends that plaintiffs lack standing to challenge the private property rule because Hawaii's law does not prevent plaintiffs from carrying firearms on any particular property. A property owner's choice to withhold consent prevents plaintiffs from doing so. We agree with the courts that have unanimously and persuasively rejected this argument. Okay, sorry.
They're not trying to hide their identities.
Plaintiff's inquiry does not depend on decisions of property owners. Plaintiffs allege that they intend to continue carrying firearms on private property, and the law requires that they seek permission before doing so, placing a new burden on their right to carry. If they carry firearms on private property without first seeking consent, as they have alleged, they will violate the law and will face threat of criminal prosecution, whether the owner decides to grant or withhold consent. Moreover, plaintiffs plausibly allege that many property owners will not post signs of any sort or give specialized permission, regardless of the default rule. Indeed, that group.
Moreover,
let's see. Indeed, that group of owners appears to be the impetus for the Hawaii to enact the law. If the group were small or did not exist, Hawaii's law would accomplish little or nothing. On a practical level, the plaintiffs plausibly attest that they lawfully visit many places with firearms, but under Hawaii's new law, they will not be able to visit those places lawfully with firearms.
So basically, they said that they have standing, and like the state. Okay,
They are thus injured by the law, and I
yeah,
can't
you
read
can
the
do this.
rest.
But they're saying that the actions to carrying the firearms falls within the Second Amendment, and they are part of the people. So basically, what California, why we're trying to do, they were trying to argue that the Second Amendment only applies to publicly owned property and not private property,
Wow.
which they're allowed to do.
Wow.
You know, they can say you can ban it in private property. The court says no, that's not the way it works, and therefore they knocked it down. And
Ballsy.
just all that BS. So let's go to the next one. Places of worship.
We hold these truths to be self-evident. Oh, sorry, I was reading something else.
A dead
In
document.
California cases, the district court held that plaintiffs are likely to succeed in challenging California Penal Code, which prohibits the carry of firearms at places of worship. Although the issue is a close one, we agree with the district court's conclusion in this regard. Places of worship undisputably have.
This basically what they're saying is since churches have been around since the founding era, they didn't ban firearms from churches. Therefore, it can't be. Interesting enough, the state tried to use three laws from 1870, 1875, and 1878, Virginia, Missouri, and Georgia in reverse order. Georgia laws 1870, Missouri 1875, Virginia's 1878, which the court found that it was 1889 and 1890 as well. I missed those, but the court found that that was too far away from the founding era.
Yeah, I was going to say that's well outside of the scope of the time frame.
Yeah.
District courts have divided on this question.
Now this is what we're talking about is if the founding era is the ratification date of the 14th Amendment, which is 1868, or the Second Amendment, which is 1791. So go ahead. This is interesting.
District courts have divided on this question and holding that the plaintiffs were likely to succeed on a Second Amendment challenge to a ban on firearms at places of worship.
Here.
I have no idea where we are.
For its part, the Second Circuit declined to reach the issue. The court vacated the injunctions in two cases because the mootness, and the court affirmed the injunction in one case as to New York's ban on carrying firearms in places of worship, but on First Amendment grounds, declining to reach a Second Amendment question.
In some, places of worship have been prevalent throughout our nation's history, but no colony, state, or territory banned firearms at places of worship until after the ratification of the 14th Amendment. At this preliminary stage, we conclude that plaintiffs are likely to succeed on their Second Amendment challenge with respect to California Penal Code Section 26230A.
All right, and they're going to say there's nothing that says that the churches themselves can't ban firearms. Gathering places that requires a permit. Go ahead, Dark.
Oh, me?
Yeah.
In the California cases, the district court held that plaintiffs are likely to succeed in challenging California Penal Code Section 26230, which prohibits carry in a public gathering or special event conducted on property open to the public that requires the issuance of a permit from a federal, state, or local government, and sidewalk or street immediately adjacent to the public gathering or special event, but is not more than 1,000 feet from the event or gathering, provided this prohibition shall not apply to a licensee who must walk through a public gathering in order to access their residence, place of business, or vehicle. What up?
What's up, Anderson Manufacturing? How you doing?
Yeah, man. I heard no, I don't think I can say that on YouTube. Never mind. Defendant does not argue that there is Code Dark is a national tradition of banning firearms, specifically at permitted public gatherings. Instead, defendant argues that there is a national tradition of banning firearms at public gatherings in general, and because permitted gatherings are a subset of all public gatherings, the challenge provision falls within the tradition. We agree with the district court that plaintiffs are likely to succeed.
All right, so they're saying that you can't ban it from the surrounding areas. Financial institutions.
In both the Hawaii case and the California cases, the district courts held that plaintiffs are likely to succeed in challenging the relevant provisions of state law that prohibit the carry of firearms in financial institutions such as banks, Hawaii Revised Statutes, Section blah, and California Penal Code, Section blah. We agree with the district courts.
All right, I'm just going to say that they ruled since 1791 there was banking, and they weren't blocking like people from carrying firearms in bank during the founding era. You can't do it. All right, Rich, take over.
Hospitals and other medical facilities. In the California cases, the district court held that plaintiffs are likely to succeed in their challenges to California Penal Code law, which prohibits carrying in a building or real property and parking area under the control of public or private hospital or hospital affiliate, mental health facility, nursing home, medical office, urgent care facility, and other place in which medical services are customarily provided. We agree with the district court. Defendant is correct that as his
You can
expert
stop this.
states,
They're basically their argument was that state's arguments were, hey, the it's a lot different now. The doctor's offices, and because they're not always in people's homes, and hospitals are a lot bigger. And they're saying, yeah, it's correct, but you couldn't do it back then, so you can't do it.
So different.
public transit. In the California cases, the district court held that plaintiffs are likely to prevail on their challenge in California Penal Code law, which prohibits carry on a bus, train, motorcycle, airplane, boat, paid in whole or in part in public funds, and building real property or parking area under the control of a transportation authority supported in whole or in part with public funds.
They're basically saying that they can't ban it on private transportation. One of the one of their thing they were saying is that there were 6 railroads that banned private firearms from the 19th century, which is outside the founding era again.
Mm-hmm.
And so they ruled that, it's not so. So basically they're saying now the remaining winter factor.
Oh, the remaining winter factors, in addition to showing
Okay,
the likelihood
one
of
thing I do
success.
want to talk about this, they're saying if they change the law to say you're not allowed to carry loaded firearms on public transportation, they're saying that they probably would allow it. But they're saying California law didn't make a distinction between loaded firearms and unloaded secured firearms. So I expect that to be changed in California law like soon.
Wow.
Dang.
All right,
In
Rich.
addition to showing the likelihood of success, plaintiffs must demonstrate that they will suffer irreparable harm in absence of preliminary relief, and that injunctive relief is consistent with the equities of public interest or challenges as to which plaintiffs have failed to show likelihood of success. We reverse the preliminary injunction. And
basically what they're saying is they're going to reverse it on the ones we talked about, that they're going to reverse it, and then they're going to affirm the other parts. So this is a mixed bag. I will say that.
It's some bullshit, but I mean, it's not total bullshit.
It's mixed bag.
The parking lot gets very complex because, like, If it's a parking lot of a
depends.
prohibited place, if it has a fence, doesn't have a fence, is shared, not shared.
Well, if
Yeah,
it's
it's very.
multiple levels, right? They
Yes.
said if there's a subgrade basement, I mean that is a convoluted. It's a difficult argument.
Yeah, it's a very confusing.
And the problem with this is the laws should be so simple that everybody understands them.
That I was literally about to say the easiest thing to do would be to allow the carry of firearms anywhere and everywhere because that would be simple to follow.
Because we know signs that say no guns allowed protect everybody's lives.
I'll tell you what, I can't recall the last time I saw a sign or went somewhere that said you can't carry a gun here that I disarmed myself. Catch me, bitch.
Well, um, in Virginia, it doesn't have a force of law.
Signs don't have a force of law.
Yeah.
However,
Or any
if
force.
one were to carry, I don't know, in a post office, or if one were to carry in a school, or if one were to carry in an area like that.
Well, that's what I'm talking about. I'm just talking about like private companies, like stores and
Yeah.
stuff like that.
Yeah, you'd have to be trespassed.
Yeah, they can trespass you 100%.
And then if you refuse to leave, then you can be.
Yeah, you gotta remember, trespass. They have to ask you to leave before they can trespass you.
Yeah.
Right.
You could walk in a store with. Sorry, Rich. Just real quick. You could walk in a bank. Even you could walk in a store that's private property with an AR slung on your back that has signs all over it that says "No guns allowed," and they could come up to you and ask you to leave. Let's say they just called the cops, but didn't ask you to leave. They would actually have to have an agent of the business ask you to leave and inform you that your presence is no longer allowed on that property, and then you have to be given an opportunity to to leave. If then you choose not to leave with the police and an agent of the business informing you to leave, then yeah, you get in trouble.
Yeah, you have to leave when they tell you to leave.
Yeah.
I love did they mention the spirit of aloha in this?
No, that's a different case. That was a state level case.
Yeah. I think he was joking.
Yeah. But Rich, I don't think Rich was.
No, I think Rich was. Rich, were you joking?
When you said
Actually, I wasn't joking because I remember the last Hawaii thing was, the
that
spirit of
that was
aloha.
a state case.
Yeah, that was specifically for
That was,
Aloha. I mean Hawaii.
told you, Dark. He wasn't.
I totally thought. I just assumed he was
In
joking.
fact, Rayman, what if I bring my own signs?
That's what we should do. Like in any places that do this, just go pit up, find firearms allowed everywhere.
Oh, dude. Sounds like we should start printing signs of some sort and giving them to people. Firearms encouraged. Thanks.
Yeah, we should.
Well, man, what a mixed sack.
I told you it's a mixed sack.
Big old sack of mixed nuts.
Yeah,
I'm going to drop out because I got to take care of something. So happy weekend, people.
Yeah, man.
Right.
See you.
Thank you for coming on. No, what I think is going to be interesting is both sides are going to try to spin it as victories.
Yeah.
So just be aware. Our side does it; they do it as well.
For sure. Yeah.
So both sides are going to do a victory. So I'm going to write a article, probably, and it's going to like not pin it as a victory on either side because it's not. It's not a victory on either side.
Yeah, I mean there are some wins. There's some positives to this, but like you said, it's a mixed bag.
Yeah.
Zanti, oh boy, y'all just got me started. Dude, Go print some crazy signs and place them wherever you'd like. Well, I don't want to encourage people to do. You know what? I'll pull a CRS and I'll say, I don't give advice, and if you do take advice from me, you're stealing. So we miss you, CRS. We love you.
All right.
Well, guys, don't forget to follow John Crump News, John Crump Live, and check out John Crump Live Mondays through Thursdays at 5 p.m. Eastern Standard Time.
Yeah, we won't be having a show next Wednesday because I got a little procedure going on. But
You okay?
yeah, fine. Just a little medical procedure.
Okay.
But yeah, also, if you want, there's a link for Otis Gun Supplies down in there. They make cleaning supplies, and they are a sponsor of the channel. So be sure to check them out.
Nice. That's what's up. Do you still have any axes?
Not right now. They're being made.
Oh, okay. So you sold out of the first shipment. Nice.
Yeah, they're coming
That's
in
awesome.
now. I got some other stuff coming in too.
Nice. Beautiful.
So with that, we're out of here. Okay. Kurt 24, a member for 12 months. Thank you so much.
Allegedly.
I thought churches were private in the states, can't tell them what they can and cannot do. The Nunye law. Yep. That's basically what this said. And with this, we are out of here. I will see you guys later.